Welcome, everyone. My name is Emily Sweeney. I'm a reporter at the Boston Globe. I also serve as president of the New England Society of News Editors, and I sit on the board of the New England First Amendment Coalition. And this seminar today, or webinar, I should say, is brought to you by NEFAC, the New England First Amendment Coalition, and also the New England chapter of the Society of Professional Journalists. And today we're going to focus on freedom of information law pertaining to Connecticut. And I'm here with Dan Barrett. Dan, thank you so much for joining us. Dan is the American Civil Liberties Union of Connecticut's legal director. His interests in the law include anonymous speech, freedom of movement, mass surveillance, and maximizing democratic control of government through open courts and open records, which I'd like to hear. So Dan, you have a ton of knowledge about Connecticut FOI law. And if you want to maybe walk us through some of it, that'd be great.
Sure. Well, thanks for having me, and hello to journalists and everybody else out there in TV land. So I guess part of the reason why we're doing this at NEFAC is to encourage people to use their State Public Records Act and to understand that there's a wealth of information that's out there. I think a lot of times it can be kind of overwhelming and dispiriting to try to get information, but I'm here to tell you that in Connecticut, at least, our law is pretty good, and you can usually get, depending on the hoops you're going to jump through, you can usually get what you're looking for. And really, I always think of this every time I've read in the past couple of years, terrific coverage from Connecticut journalists, whether it was, the Paul Witherspoon shooting in Hamden that involved a lot of FOI work, Kellen Lyons and Lisa Backus's coverage of COVID in the Department of Correction, and especially their long history of understaffing medical care there. I mean, that work was all powered by hard work and our Open Records Act. So there's a lot of good stuff that's out there. I'm also thinking of the nightmare kind of coverage of like the state police, very hard to get records from the state police. And so, there's other corners of government that have been kind of resistant to it. But what I want to walk you through this evening is just the kind of basics of using it and, what you can get and who you get it from. So when you're thinking about getting information from the government, a government entity in Connecticut, I guess the first step I would take is think about, is the thing that I'm, is the agency that I'm asking for information, is it what we know as a public agency, which every public agency in Connecticut is bound by our Freedom of Information Act. And it's a really easy answer. That is, if the agency is in any way connected with the government, so according to the statute, that's any executive, administrative, or legislative office of the state or a political subdivision of the state, which in Connecticut means cities and towns, we don't have county government, then it is bound by the FOI Act. So as long as you're talking about the government, you can't really go wrong. There's a couple of little exceptions that are worth noting. The first is that when it comes to our state courts, their records are open under our Freedom of Information Act, but only to the extent that they're administrative records. If you're looking for case records, the judiciary has its own body of law that, if you're interested, we can kind of pick up later, or you can ask me directly. But if you want an FOI request, for example, like salaries, any kind of administrative data, the judiciary is right there. We do have some notable exceptions, and this shows you kind of how the game is played in Connecticut. You've got our state prosecutors are completely off limits from our Open Records Act. So we have a unified state prosecutorial arm, and it has gotten itself exempt from FOI. There may be ways around that, but that's what's written in the statute. The other thing to note, if you're into following up on when cities, towns, and their employees get sued, CIRMA, which is the Connecticut Intermunicipal Reinsurance, I can't remember, Intermunicipal Risk Management Association. So it's the municipal insurance pool that a lot of towns use to insure against risk. CIRMA itself is off limits, but that's okay. You can get what you need through the towns. Those are pretty much the only exemptions. So if you come into contact with a town or some government department that tells you it's not part of, it's not covered by FOIA, it's probably wrong. Private entities sometimes can also be covered by FOIA, but really only to the extent that they're performing a government function in the place of the government. So for example, there's a very few limited number of towns that don't have their own schools and they contract out with private schools. Maybe that would be a situation which those schools would be covered by FOIA. But generally speaking, that's the universe we're talking about. And that means you can get information from all of those sources, executive, legislative, or judicial. The second thing I would think of when I'm considering whether to get information and how is whether the information that you're looking for is a public record. And again, in Connecticut, that answer, technically speaking, is almost always going to be yes. Our Public Records Act encompasses, and here I'll read you the statute, any recorded information relating to the conduct of the public's business that is prepared, owned, used, received, or maintained by a public agency. So we're talking about anything that passes through its little fingers. But here's the distinction I want to draw to your attention. Any recorded information. So that means in whatever form, whether it's electronic, it's written, it's a fax, whatever it may be, that's fair game. But the flip side is that if it's not written down, it's not recorded anywhere, it's not subject to the act. And the way that you might come up against that in your work as a journalist or as a concerned citizen is that if the record doesn't exist, the thing that you're looking for isn't written down, they don't have to give it to you. They don't have to create it for you. So if you make a request for, let's say the OPM, the Office of Policy and Management in Hartford, it produces a lot of very interesting statistical reports about the government, but you want a report that says something that really complex and they haven't done it. You can ask them for it and they might, out of the goodness of their hearts, create it for you, but they don't actually have to. So if you're asking for something that doesn't exist, don't be surprised if they tell you to go pound sand. The other thing that the definition of public record means, any recorded information, is that the agencies don't have to answer your questions. Of course, most folks, I'm assuming, are reporters, and so you know how to get questions answered. But sometimes people try to use the Public Records Act to ask questions like, well, I heard in a meeting at Town Hall last week that you were going to repave this road. Is it true? Technically speaking, the town can say, we don't have to answer that. All we have to do is produce records to you. So if some of your work or some of your areas of curiosity involves getting a question answered, whether something is going to happen or not, you may want to phrase your question as such that if there are records that are responsive to it, it's a yes. If there are no responsive records, it's a no. For example, excuse me, records showing the number of occurrences on which this thing happened, right? If the answer is we don't have any records showing that it ever happened, that's a pretty good indication that it never happened. But sometimes people ask direct questions and they're surprised to learn that agencies don't have to answer them. The next biggie I would cover is the form of the request. Sometimes this comes up. Agencies will tell, especially reporters, reporters make oral requests. You go up to the counter at the clerk's office. You say, hey, I want the school department's budget for this upcoming year. And sometimes the clerk will say, well, no, you have to write that down. Well, that's not right. A verbal request in Connecticut is a public records request. So is an email, so is a fax, however, skywriting, however you want to do it. But of course, as with everything else, if you think that you're dealing with maybe an agency or an employee that sounds like they want to dodge your request, a written request might be a really good idea. But strictly speaking, they don't, they can't just turn you down and say, oh, you have to send it to us via telegram. Particularly if anyone has come to contact with, for example, Bridgeport. Bridgeport has this online system that they'll demand you fill in all the fields and do this work and type it in. I always tell them, I'm sorry, I'm not required to do that. And by the way, I'm right. I don't have to do that. I give you the request. If you need to type it into a computer, that's your business. But a public records request can be oral. So, all right, you found your agency, you know what you're looking for, and you make the request. And so what happens after you do that? And in Connecticut, in theory, there's really only two things that can happen. The first is the agency has to, and this is the word the statute uses, promptly produce the records to you. And that's either a copy, if you ask for a copy, or inspection, meaning you will show up and actually look at the record. Or number two, the only other thing they can do is deny your request in writing, and it's either within 4 business days or 10 business days. The 10 is for personnel records, and we'll talk a little bit about that in a minute. That's it. So either here you go, or no, you can't have it. Here's the thing though, in Connecticut, because the statute is not drafted particularly precisely, a lot of times agencies will do neither, and they will simply ignore your request. if that happens, the statute says a failure to either respond or deny shall be deemed a denial. So as we'll talk in a minute about what happens when you get denied, you could, if you wanted to, take that directly to the Freedom of Information Commission and say, hey, I've been denied. They've ignored me. So bear that in mind. Those are the only two answers. If you get a different answer like, oh, the boss told me I shouldn't give you that record, or whatever it is, I don't feel like giving it to you, that's the wrong answer. If they're going to deny you, it's got to be in writing. They got to tell you why. Now, when the agency gets the request, another issue that sometimes comes up is how far the agency has to look. And if you've done this before, sometimes I had a case with Hartford in which I had a police officer who testified that she got my request in the mail, and I asked her, when was the first time you looked for records? And she said, today, the day of the hearing. And I said, okay, what'd you do? She said, I walked into my colleague's office. I asked her if we had these records, and she said no. That was the whole search. The woman never looked up from her computer. She said, no, we don't have any records. That's not good enough. The agency that you're asking for records has got to do a diligent search and figure out where these records are. And here's the kind of 2021 spin on this part of the law, is that the act requires that the agency produce all responsive records to you over which it has what's called custody or control. And what that means is not just stuff that they look on their desk and they say, oh, here we go, I got it right here, but stuff that they may store, for example, off-site, or in today's world, they may store it on the cloud or have somewhere that's not actually in town hall or something like that. I have repeatedly run up against towns that want to play the game of saying, for example, oh, yeah, we had this cop who got sued 14, 15 times. We settled the cases, but we don't have the records. Those are with the lawyer we hired to defend the cases. He's not here in town hall, so I can't give them to you. That's a wrong answer. So don't take that for your answer. They have to go look. And it doesn't matter if they store it via Google or Microsoft. It's the same thing. You gotta, if they have the ability to get it, they have to go get it for you. So let's say they call you up and they say, well, Emily, I got your request. I got your records right here. What do you want to do? As I alluded to earlier, you have two choices. You have what's called inspection, and then you have copying. Inspection, you got to truck on down to City Hall and go look at the records. And that can be a really good deal in Connecticut because it is free. They have to lay the records out for you and you can just kind of whip through them. And that may make sense if you don't know what you're looking for, or if you've made a request that's likely to yield a lot of pages. So for example, you ask for a whole, I want to know they're going to repave my street and I want to know everything about it. And they say, oh, we get the plans, we get the bids, we get all that stuff. Well, it's going to be hundreds, if not thousands of pages. So you probably want to go down and take a look. You probably only want a couple of those pages. So inspection is that can be a good opportunity. But if you want copies, that usually involves money. And the reason is that our law permits municipalities and state agencies to decide what form they're going to give you the record in. So even though it's 2021 and most people don't really deal in printed records anymore, they will often insist on mailing you a printout because they can charge you for it. And in Connecticut, municipalities can charge 50 cents a page. Obviously, it doesn't cost that much to produce a copy, but that's what they do. And the state can charge 25 cents a page. So, I would try sweet talking and say, hey, could you just email it to me? But ultimately, if they want to, they can print it out and then charge you for mailing it. But that's the cap, 25 cents for the state, 50 cents for municipalities. The only other kind of wrinkle to note, and this sounds awfully like late 90s now, but there was a big fight back then about handheld scanners because people would come in for inspections. Savvy journalists like you all would come in for inspection and say, well, I want a copy, but I don't want to pay 25 cents for a copy or 50 cents. So I'm going to bring a handheld scanner. So our law says that if you do that, the agency can set its own fee, but it can't exceed $20 per visit. I can tell you that I've been to town clerk's offices. I think Glastonbury was one of them. They had an absolutely gigantic sign, like wider than I am tall, that said, anyone using a handheld scanner will be charged money. So, these days, I don't know what they do with phones. I myself have surreptitiously used my phone to take photos when I'm inspecting. Some town clerks don't care. Some state agencies could care less, but just beware that they may tell you that it's the handheld scanner price. But the headline with costs, so you've got your they're going to charge you for copies, but what they're not charging you for is labor. So if you get an answer that says, Emily, we got your documents, we found all the stuff relating to the highway overpass we're building, and our lawyer had to go through it, and it took 6 hours, and so that's going to be $2,200. Wrong answer under our law. I guess the other thing I should talk about, I guess at the very end we'll talk about what happens if you get denied, but I want to quickly talk about there's a few exceptions to the law, as anyone who's used it has probably figured out. And at least from my work, I've picked out 4 that I come into contact a lot with and that I see in the paper a lot. Maybe this will be helpful, but figure we just kind of whip through them, things you might see if you make a request. The big one, of course, because I'm an ACLU lawyer, the big one for us is the police records exception. And it's not as bad as it sounds, but it provides that certain records, and it's somewhat complex, but it's records of law enforcement agencies that are not available otherwise to the public, and that were compiled during the course of detection or investigation of crime. Certain of that subset can be held back. For example, the identities of confidential informants, the identities of a minor witness in a criminal case, the signed statement of a witness. Oftentimes cops collect statements from witnesses on the scene. They can hold those back. Information used in a future investigation if it will be prejudicial to that. So for example, if you're asking for a case file, you think your neighbor's under investigation, they haven't arrested him yet, they may turn you down. There's another one called investigatory techniques not otherwise known to the general public. That's got to be something really secret. We did some work finding out which police departments use drones, and Bridgeport, for example, the Hall of Shame, claimed that if people knew whether or not Bridgeport had drones, people would drive to Bridgeport to commit crime that could be stopped by drones. I didn't understand it. We won the case pretty easily. But sometimes you'll get that. They'll tell you, oh, it's so secret that it's probably not. The other kinds of things that you may run into with police records is the arrest records of a juvenile are generally off limits in Connecticut. Unsurprisingly, the name and address of victims of sex assault are off limits. And this relates to the next exemption we'll cover, what we call uncorroborated allegations. And Connecticut has, this is understandable, but ends up playing out in a kind of a vexing way, an exemption that says uncharged conduct ends up being off limits. So that statute says that police agencies' records that contain uncorroborated allegations of criminal activity have to be reviewed and destroyed if, and the statute says, the criminal activity cannot be corroborated. And how you will see this play out is, in the most benign case, it's someone who's arrested and it turns out, and trust me when I tell you this is super rare, the cops decide out of their own, the goodness of their heart that they made a mistake and the person should not have been arrested or charged with a crime. Then they'll tell you, I'm sorry, we can't, those records are off limits, can't give them to you. More often how you'll see it work is someone who is in a position of power or who has some influence gets picked up for something embarrassing, sweet talks the cops into letting them off, and we can't see their records. I think back in the time of John Rowland, if I'm remembering correctly, I think his kid had a kegger at the house. Cops show up, everybody gets arrested because they're all underage. Lo and behold, the next morning, the charges get deep sixed, and the journalists looking for the records are told, I'm sorry, that's uncharged conduct. You can't have the records. We can't tell you anything about it. You might run up against that. The other two I want to hit, and I hope that I'm not boring you to death, but these the other two that we should talk about are personnel records, because that comes up a lot, and so-called deliberative process. So personnel records in Connecticut can trigger some protection. And when you're looking for public employees' records, they are generally available, although agencies will often tell you otherwise. They're generally available unless the revelation of the record itself would cause a really serious sort of personal embarrassment, like the loss of friends, the loss of employment. It's got to be really serious. And here's the key, though. Just because the employee did a terrible job or was reprimanded or was stealing public funds or whatever it is, that won't cut it. So oftentimes public employees, particularly police, will say that, every time they get caught screwing up, well, that's an invasion of privacy. We can't release the records. They're wrong. They're almost always wrong. So it's got to be something like really serious. Let me give you an example. a person who, let's say they get disciplined for repeatedly showing up to work late, and it turns out it's because they have a medical condition of some sort, that's probably off limits. And I'd be the last person to argue about that. But when it comes to the guy who's caught sleeping on the job, that won't cut it. You can get those records. Here's the only wrinkle about personnel records, though, in Connecticut. Our statute requires that the employer tell the employee about whom the record's concerned that there's a request. The employee can ask the employer to hold on to the records, and they almost always do. And then you have to go to the commission. So it can take a while, but at the end of the day, you can probably get what you need. And the very last thing I want to hit is what we call the deliberative process exemption. And that's for information like memos, drafts, things like that aren't final. So for example, we know Governor Lamont is, he's formulating a policy on sports betting, let's say, and you ask for, all right, give me all the emails that went into the decision to permit sports betting or to propose the bill on sports betting. Well, he might turn you down and say, you're allowed to see where I landed on sports betting. I have an internal memo saying we're going to ask the ledge to make it happen. But everything before that, when it's still in the back and forth phase, they may turn you down. You can sometimes get that with towns too, where they're kind of formulating policy. Okay, the last thing I want to hit is what happens if you get denied. What do you have to do? And in most jurisdictions in New England, this would not be a very involved topic. It would be sort of, you do what you want, you can file a lawsuit. Here in Connecticut, it's a little wacky. If you get denied, you have to what's called appeal within 30 days. And you appeal not to the courts. You don't file a lawsuit, but you have to go to what we call the Freedom of Information Commission, which is down on Trinity Street in Hartford. And it's an administrative agency. But the key is 30 days. If you let it go longer than 30 days, by the time you get to the commission, they may tell you, I'm sorry, you waited too long to appeal. So the way that can get tricky and play out in a journalist's work or a concerned citizen's inquiry is when the agency ignores you. And that's often the game they play. They get your request and then they wait, let's say 2 months. And then they say, well, we're not going to give you the records. If you appeal it at that point, the commission may tell you, I'm sorry, you waited too long. You waited 2 months instead of a month. So if you really want the info, when you send off your request, start counting, mark a calendar. When you get to day 59, file your appeal with the FOIC. Once you do that, it'll get into the queue, and at some point you'll have a hearing. It's very relaxed. It's not a lot. It's not like court. It's more like the zoning board, and then they'll give you a decision. That's kind of the nutshell version of open records in Connecticut. Anything else that I should hit, Emily?
Yeah, that was a great overview, and I seriously, I just learned a ton. I wasn't aware of. We do have 2 questions I noticed in the Q&A box here. The first one came from somebody asking if you requested a FOIA to the DA for the last 3 years, convictions, charges, or dismissal of custodial interference, and they denied your request, then who would you contact regarding that denial?
So I think if you were denied the record and you thought that you were wrongly denied, you should file an appeal with the FOIC, the Freedom of Information Commission in Hartford. Now, as I said, the one caution is that the state's attorney's offices are under our statute off limits. There may be some arguments that you could get some records from them. Maybe there's a way around it, but I think I would, no matter who is the agency, if I thought I was wrongly denied, I would file an appeal with the FOIC. It's very informal to do that. You just write the FOIC a letter, include your request, the one that you made. If you got a denial in writing, include that and just say, dear FOIC, I would like to appeal this denial. Here you go. And that'll do the trick.
Okay, great. And then the second question, somebody's asking, does Connecticut law recognize any sort of GLOMAR response from law enforcement?
Yeah, great question. Tough issue. So the answer is no, not yet. Let me explain what GLOMAR is. And then this, you could waste a lot of hours on Wikipedia on this. In this, I wish this were fake. This sounds like sci-fi. In the 70s, there was an accident with a Russian nuclear submarine, a Soviet submarine. It sank to the bottom of a very deep part of the ocean. But it was thought to be by our government largely intact. Our government paid for, it bought an oil exploration ship, I think from Howard Hughes. and it was called the Global Explorer. And it built a giant extraction arm that reached down to the bottom of the ocean, grabbed the submarine, and attempted to lift most of it to the surface, all without anyone noticing. And a journalist or two somehow got wind of it and made a request to the national government for records regarding that time you rented a ship and tried to get a submarine off the bottom. And the government's response was, and this is called the Glomar response, we can't tell you whether there are records or not, because merely by telling you whether there are records or not, that would compromise national security. And this gets to when I talked to earlier about the way you get questions answered through the Open Records Act, where you can ask them, for example, if I wanted to know whether this incident happened, I would say, produce to me all records showing the occasions on which the government rented a oil exploration ship for the purpose of raising a Soviet submarine, right? If they say there's 3 records and we're withholding them, bingo, I know that you did it, right? And if they say we have none, then I know that you didn't. So sometimes agencies have smartened up and said, well, we're going to give this Glomar response. To more directly answer the question, I have never run across it. The closest I have come was in that series of cases we did, including the one I mentioned in Bridgeport, where we asked law enforcement agencies whether they had certain items of technology, drones, whether they had cell site simulators, which used to be called Stingrays and are now called something else. And then that Israeli software that interrogates iPhones. If you plug it in, it will dump the contents of your iPhone. We asked about all of that. It's called Celebrite. And Bridgeport, without knowing it, came very close to giving a Glomar response, saying basically, we can't even tell you whether or not we have drones, because if we did, then criminals would come to Bridgeport. And I thought that the way that our particular exemption is worded on that, our law enforcement exemption is worded on that issue, on the investigative techniques, doesn't necessarily allow for a Glomar response. But as far as I'm aware, to directly answer your question, we do not have such an exemption in Connecticut.
Dan, this has been so informative, and I just want to thank you for giving us a great overview of the FOI law in Connecticut. I want to thank everybody who joined us. If you go to NEFAC.org, we're going to be having a series of these FOI webinars, and for each state, and then including at the federal level. So be on the lookout for them. And again, if you go to NEFAC.org, you can sign up and register. And also, I want to thank not only NEFAC, but also the New England chapter of the Society of Professional Journalists for co-sponsoring this event in this series. It's been very informative so far, and I'm looking forward to more. So thank you so much, Dan. I really appreciate it.
Hey, thanks, Emily. Thanks for having me.
Yeah, it was great. Take care, everybody.